Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. We come to you today to give you an update that took place after Friday's episode aired. The Supreme Court granted certiorari in 4 cases. You probably saw details about one case, Birthright Citizenship. The Supreme Court also granted 3 more. TMV, University of Maryland Medical System Corporation, decides when people can challenge state court decisions in federal court while their state appeals are still going. Abuamo vs. United States asks whether prosecutors can pick their favorite courthouse based on where they think a crime's effects might be felt, and whether the government can use legal tricks to buy themselves more time to file charges. Jules v. Belaz. Properties determines whether federal courts that send cases to arbitration can still handle the final paperwork when arbitration ends.
We'll briefly run down those cases and let you be on your way. But remember, the Supreme Court hears major cases this week, so we won't be dark for long. Before we begin, make sure you subscribe and comment via the High Court Report YouTube page. Navigate there to listen to oral argument clips and engage in discussion. I upload YouTube shorts often. Also, subscribe to the High Court Report podcast and follow the High Court Report on LinkedIn. On LinkedIn, I provide daily rundowns of Supreme Court cases and post informative graphics. Finally, please rate and share the High Court Report with friends, family, coworkers, neighbors, or anyone who wants to follow the Supreme Court.
Okay, let's get going. Here's what you need to know. First, let's discuss the case that got the attention, Trump versus Barbara, the Birthright Citizenship case. This story actually starts with a case the court already heard, Trump versus CASA.
That's right. Back in May 2025, the Supreme Court heard oral arguments about universal injunctions in Trump versus CASA. The government wanted to limit how broadly courts can block executive policies. But underneath that procedural fight lay this massive constitutional question about birthright citizenship. And during those CASA oral arguments, Chief Justice Roberts made a telling comment about the court's ability to move quickly. He said, "We've moved much more expeditiously. I think we did the TikTok case in a month. Any reason in this particular litigation that we would remain unable to act expeditiously." That comment came as justices worried about courts being unable to protect constitutional rights when they can't issue universal injunctions.
Justice Jackson also expressed concerns that forcing plaintiffs through class certification procedures could prove discovery intensive and really delays plaintiffs from getting the relief that they seek. Her point: universal injunctions actually help resolve constitutional questions faster.
But the most revealing moment came when Justice Kagan told the government lawyer, "Let's just assume you're dead wrong on the constitutional merits." That phrasing strongly suggested she believes the executive order violates the Constitution.
So the court limited universal injunctions in CASA while explicitly avoiding the constitutional merits. Now they've granted cert before judgment in Barbara to address the very constitutional question they sidestepped. The urgency tells us everything about the stakes here.
The Supreme Court granted cert on this question. Whether the phrase "subject to the jurisdiction thereof" in the Citizenship Clause requires that a person's parents have lawful domicile in the United States at the time of birth. Let me read you the key constitutional text that governs this whole dispute. The 14th Amendment states, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside."
Those 5 words, subject to the jurisdiction thereof, now determine the citizenship fate of hundreds of thousands of children. The government argues these words require parental domicile, essentially lawful permanent residence.
But here's what strikes me about that text. The amendment doesn't say "subject to the political jurisdiction" or "subject to the complete jurisdiction." It just says "jurisdiction," period. And temporary visitors still follow our laws, pay our taxes, and face our courts.
Exactly. And the Supreme Court addressed this exact language in 1898 in a Supreme Court case, United States versus Wong Kim Ark. That decision held that children born here to immigrant parents become citizens automatically, even if the parents can never naturalize themselves.
To set the stage, President Trump issued Executive Order 14,160 on January 20th, 2025, declaring that federal agencies shouldn't recognize citizenship for children whose parents either entered illegally or remain here temporarily. The order targeted two specific groups: children of unauthorized immigrants and children of temporary visitors like tourists or students.
Within days, multiple lawsuits erupted across the country. District courts in Maryland, Massachusetts, Washington State, and New Hampshire all issued preliminary injunctions blocking the order. Every single court that examined this order ruled it likely violates the Constitution. But here's where the CASA decision created complications. The Supreme Court ruled that district courts can't issue universal injunctions protecting everyone nationwide. They can only provide relief to actual plaintiffs in each case. This created problems for the Barber case because the district court granted class certification to protect all affected children nationwide.
The CASA decision revealed something critical about the constitutional merits, though. The majority completely avoided ruling on whether the executive order violates the Constitution. Justice Barrett wrote, "The birthright citizenship issue remains not before us. We take no position on whether the dissent's analysis proves right." However, Justice Sotomayor's dissent, joined by Justices Kagan and Jackson, declared the executive order patently unconstitutional and said the court's precedent establishes, beyond a shade of doubt, that birthright citizenship applies broadly. The Supreme Court then granted certiorari before judgment in Barbara, which means they skipped the normal appeals process to hear this case directly. Chief Justice Roberts' earlier comment about moving expeditiously seems prophetic. The court recognized the urgent constitutional importance of resolving this question.
Now let's quickly walk through the high-level details. The central question involves whether the phrase "subject to the jurisdiction thereof" in the 14th Amendment requires that a person's parents have lawful domicile in the United States at the time of birth. President Trump's Executive Order 14,160 declared that federal agencies shouldn't recognize citizenship for children whose parents either entered illegally or remain here temporarily.
The government argues that "subject to the jurisdiction thereof" requires political allegiance based on lawful domicile. They cite 19th century authorities claiming that domicile determines whether children of non-citizens get treated as citizens. The respondents fire back by claiming the executive order violates Federal Statute 8 U.S.C., Section 1401, which Congress enacted in 1940 and 1952 to codify a Supreme Court precedent, Wong Kim Ark. They argue that even if the Constitution were ambiguous, the statute clearly protects birthright citizenship.
How did the case shake out in the lower courts?
Every single court that examined this order ruled it likely violates the Constitution. The government argues those 5 words require political allegiance through lawful domicile, while respondents defend the traditional rule from Wong Kim Ark that birth on American soil generally confers citizenship. But the court ruled in Trump's favor at the universal injunction stage. Would the court choose that case to put their foot down on universal injunctions if they truly didn't think the case was closer than how Justices Sotomayor and Kagan said?
Excellent question. When we repair our case preview, we'll see what other the breadcrumbs the court left behind in Trump versus CASA.
What are the stakes?
Hundreds of thousands of children born each year could lose automatic citizenship rights if the court sides with the government. These children would face potential statelessness, denial of federal benefits, and exclusion from full civic participation. This case tests how the court approaches foundational precedents and could reshape American constitutional law for generations. We'll definitely cover the oral arguments and eventual decision closely. This case represents one of the most significant citizenship disputes since Wong Kim Ark itself, and the court's ruling will shape American constitutional law for generations.
Our second case is TMV University of Maryland Medical System Corporation, also granted cert on December 5th. This one's about the Rooker-Feldman Doctrine, a jurisdictional rule that determines when federal courts can review state court decisions.
What's the basic situation?
TM was a psychiatric patient who entered a consent order in Maryland State Court for her discharge from the hospital. 2 weeks later, she appeals that order to the Maryland Appellate Court, but then also files a separate federal lawsuit claiming the consent order violated her constitutional rights under duress.
So she's got 2 cases running at the same time?
Exactly. And here's the kicker. She asks the state appellate court to pause her own appeal while the federal case proceeds. The question is whether federal courts can hear constitutional challenges to state court decisions while those state proceedings are still ongoing.
And there's a circuit split.
7 circuits on one side, 3 on the other. Most circuits say Rooker-Feldman doesn't apply when state appeals are still pending. You can only invoke it after state proceedings completely end, but the 4th, 6th, and 8th circuits disagree.
What are the stakes?
This determines when people can get federal review of alleged constitutional violations in state court proceedings. If TM wins, it opens the door for more federal constitutional challenges while state cases are ongoing. If the hospital wins, people have to exhaust all state appeals before getting federal review, which could take years. So it's really about the balance between state and federal court authority.
Right. And the practical impact is huge. This affects access to federal courts for constitutional claims and could influence forum shopping strategies nationwide.
Next up is Abuamo v. United States, which got cert on December 5th. This case involves a former Twitter employee who helped Saudi Arabia identify dissidents by accessing confidential user information. What are the legal issues?
2 big criminal procedure questions. First is venue. Can you prosecute someone where the intended effects of their crime occur, even if all their actual conduct happened somewhere else? Here, Abuamo created a false document in Seattle but emailed it to FBI agents in San Francisco, and he was prosecuted in San Francisco.
And there's a circuit split on this?
6-1 split. Most circuits say venue based on effects is only proper when effects are an actual element of the crime. The Ninth Circuit alone says it's enough that the statute contemplates those effects through an intent element. The second issue is whether the government can extend the statute of limitations by filing an invalid felony information, one where the defendant never waived his right to grand jury indictment.
What are the stakes?
This could determine whether federal prosecutors can forum shop by manipulating which agents participate in investigations. It also affects whether the government can extend charging deadlines through procedural maneuvers. These rules will impact every federal prosecution involving government investigations, false statements, and computer crimes. So we're looking at fundamental questions about prosecutorial power and defendant protections in the federal system.
Exactly. Now let's turn to our 4th case, Jules ver Balaz Properties, which got cert on December 5th to resolve confusion created by the court's own 2022 decision in Badgerow v. Walters. What's the main issue here?
Whether federal courts that stay cases for arbitration can later decide post-arbitration motions to confirm or vacate awards, even when those motions don't independently establish federal jurisdiction. It sounds technical, but it affects every arbitration dispute nationwide.
How did Badgerow create this problem?
Badgerow said federal courts can only hear post-arbitration applications if the application itself establishes diversity or federal question jurisdiction. Courts can't look through to the underlying dispute, but that creates a bizarre gap where federal courts can start the arbitration process but might lack jurisdiction to finish it. Here's the scenario. An employee sues under federal civil rights law, the court stays for arbitration, parties arbitrate, then return seeking to confirm the award. Under Badgerow, that confirmation motion only involves state contract law between non-diverse parties.
So there's a circuit split?
Right. The jurisdictional anchor theory says initial federal jurisdiction continues through post-arbitration motions. The independent jurisdiction approach requires separate jurisdictional basis for every motion. Only the 2nd and 4th circuits have clearly addressed this post-Badgerow.
What are the stakes?
This determines access to federal courts for arbitration disputes and could encourage forum shopping. Jules argues parties might file unnecessary federal lawsuits just to guarantee federal forum access later. But it also affects whether arbitration gets resolved consistently across different regions.
So the court may feel compelled to clean up this area.
Exactly. The decision will either eliminate federal court access for many post-arbitration disputes or cement a system that some argue encourages strategic forum manipulation.
Those are our 4 new CERT grants from December 5th. All involve fundamental questions about federal court jurisdiction and the balance of power in our legal system. We'll be sure to preview the cases as oral arguments approach. That's it for today's episode. Thanks for listening to the High Court Report. Make sure to follow, rate, and share the podcast. Also, we always welcome fan engagement. So comment on LinkedIn, YouTube, or email if you have any questions or comments. Talk to you soon.